Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I am your host Urvashi Chauhan, here to bring you daily developments, landmark judgments, significant rulings and expert insights from the world of law. Let us begin with the headlines and a concise overview of the top stories. After that, we will delve into the full details, providing in-depth coverage and analysis of each update. The Supreme Court has issued notice on ex-Chhattisgarh civil servant Saumya Chaurasia's plea for bail in a PMLA case. The Supreme Court has rejected a tenant's claim for ownership based on settlement with the landlord, saying that no transfer of title in absence of a registered document is possible. The Karnataka High Court has ordered a departmental inquiry against policemen for filing false chargesheet under the NDPS Act against students affecting their career. The Allahabad High Court has sought UP government's reply over demolition of a house without following procedure of law. In a plea dealing with rampant use of cool lip tobacco products by school children, the Madras High Court has impleaded the Ministry of Health and Family Welfare. The Madhya Pradesh High Court has expressed disappointment towards the lenient laws in the country so far as juvenile offenders are concerned. The Travancore Devaswam Board has filed an affidavit before the Kerala High Court stating that Shakha activities, mass training, weaponry training are prohibited in temple premises. The Supreme Court bench of Justices Suryakant and Ujjal Bhuya has issued notice to the Enforcement Directorate on a petition filed by Chhattisgarh's suspended civil servant Saumya Chaurasia, challenging denial of bail in a money laundering case. Chaurasia, former Deputy Secretary to Ex-Chhattisgarh Chief Minister Bhupesh Baghel, is accused in a money laundering case relating to coal scam. She has been in jail for over 1.5 years now. According to the Enforcement Directorate, the investigation has revealed a massive scam involving the illegal levy of 25 rupees per ton of coal, with the funds allegedly reaching 500 crores within 16 months. This money was purportedly being used for election funding and bribes. In October 2022, it conducted raids leading to the arrest of IAS officer Sameer Vishnoi, coal businessman Sunil Agrawal, his uncle Lakshmi Kant Tiwari and kinpin Suryakant Tiwari. In December, the central agency arrested Saumya Chaurasia. She has now approached the Supreme Court challenging Chhattisgarh High Court's order of 28th August this year, whereby her third bail application was dismissed. The Supreme Court has now issued notice and the matter is next listed on 20th September. The Apex Court has ruled that a tenant cannot claim ownership of a property based on a settlement with the landlord. The court emphasized that ownership transfers require a registered document and a settlement agreement alone does not grant ownership rights. In this particular case, the landlord wanted to evict the tenant due to the property's poor condition, for which he filed an eviction case. Later, they reached a settlement where the tenant would stay if he paid 12,000 and the application seeking eviction of the tenant would deem to be dismissed. Whereas, if the tenant failed to pay the amount, then the application seeking eviction of the tenant would be deemed to be allowed and the tenant would have to empty the premises. The tenant paid the amount and claimed ownership based on this settlement. The trial court and the first appellate court held in the landlord's favor and refused to grant a permanent injunction against the landlord to the tenant. However, the High Court in the second appeal reversed this by holding that as per the settlement deed, the tenant had become the owner of the suit premises upon deposit of the amount of 12,000, and since he became the owner and had been dispossessed by the landlord, he was entitled to a decree of possession. However, the Supreme Court has now overturned this decision. The bench of Justices Pankaj Mittal and R. Mahadevan clarified that the settlement only addressed eviction and did not include a transfer of ownership. Therefore, the tenant could not claim ownership without a proper registered transfer document. In the next update, the Karnataka High Court has directed initiation of disciplinary proceedings against 3 policemen for having filed a false charge sheet against 2 persons under the NDPS Act. According to the police officer Rajkumar, who was on probation in 2019, he received credible information that few persons were consuming ganja near the Krupanidhi College. Therefore, a complaint was registered and, as necessary in law, blood samples were drawn and sent to the Forensic Science Laboratory, which on testing of blood samples opined that it did not contain any contraband substance. But even after the FSL report, Kumar filed a charge sheet against the 2 persons and the court took cognizance of the same. Seeking quashing of the case, they argued that they were deliberately framed in the case only to be harassed. They informed that due to such framing, they had lost several opportunities of employment and were now getting employment offers from the USA but unable to travel because of pendency of the narcotic case. The prosecution, seeking dismissal of this petition, acknowledged that the FSL report and the charge sheet submitted by the police were contradictory, and they also noted that while the petitioners were allegedly found with 15 grams of ganja, it was not sent to the FSL as required by law. The court, on going through the records, noted that Section 27 of the NDPS Act makes it an offence of any person consuming any narcotic drugs or psychotropic substance. And if consumption has to be proved, the primary evidence would be presence of contraband substance in the blood sample. A single judge bench of Justice M. Nagprasanna allowed the petition and quashed the prosecution's case. The court emphasized that while it is crucial to tackle the issue of narcotic drugs and psychotropic substances with a firm hand, it is equally important to do so by following the legal procedure. Any violation of the procedure could result in dismissal of cases, allowing the accused to escape due to legal loopholes left by the authorities. In the midst of the ongoing controversy surrounding the bulldozing of houses and properties of individuals accused of crimes, and with the Supreme Court expressing concerns over such actions, a new case has emerged from the state of Uttar Pradesh. Sunil Kumar is a resident of Azamgarh district of UP. His house was demolished by state authorities right after an order was passed against him in July this year under Section 67, subsection 5 of the UP Revenue Code 2006. This section deals with cases where property entrusted to a Gram Panchayat or local authority is damaged, misused or illegally occupied. The local officer or the Lekpal had reported that Sunil had built his house on a public pathway. Based on this, a notice was sent to him asking him to explain why he should not be evicted for unauthorized construction. But finding Sunil's response to the notice unsatisfactory, the assistant collector then ordered his eviction. Sunil appealed this decision to the additional collector, arguing that the report was false and that the land belonged to him. However, the additional collector rejected his appeal and upheld the eviction order. Shortly after this, the authorities demolished his house. Now, the Allahabad High Court has sought the state government's response over the demolition carried out without following the procedure of law. A bench of Justice Prakash Padya directed for an affidavit of some senior officer of the Revenue Department to be filed explaining under what circumstances, without following the procedure of law, Sunil's house was demolished. The matter will now be taken up on 18th September. Stay tuned. Justice Bharat Chakravarti of the Madras High Court has granted bail to a man who was found in possession of 27 packets of cool lip tobacco products. He was thus charged for offences punishable under BNS for intentionally administering harmful substances to hurt someone or commit an offence, and under the Cigarette and Other Tobacco Products Act of 2003. Significantly, the court has impleaded the Ministry of Health and Family Welfare, the Secretary to Government School Education Department and the Commissioner of Food Safety and Drug Administration in Tamil Nadu to deal with the rampant use of cool lip tobacco products amongst school kids in the state. The court noted that it was witnessing seizure of large quantity of cool lip products. The court also noted that in some videos, school children were seen using tobacco products, which then lead to them sitting in a dazed condition. that using these products would eventually lead to school children going further for ganja and other narcotic substances. Though the state government had banned the product inside the state, huge quantities were still being smuggled into the state and being sold. Thus, the court observed that the matter had to be inquired into in detail, only after which the question of bail in cases of interstate sellers could be determined. However, in this matter, the court granted bail to the petitioner, considering that the case had been posted to a longer date for hearing and that he had been in custody since 25th August this year. While upholding conviction of a juvenile for rape of a 4-year-old girl, the Madhya Pradesh High Court has expressed disappointment towards the lenient laws in the country so far as juvenile offenders are concerned. The incident occurred in December 2017 when the victim's mother discovered her 4-year-old daughter unconscious and bleeding from her private parts after being taken upstairs by the appellant. The appellant, along with 7 other juveniles, had absconded in November 2019 and remained untraceable. He was convicted by the Sessions Court under IPC and the POCSO Act and sentenced to 10 years of rigorous imprisonment. His counsel before the High Court argued that the case was fabricated due to a rent dispute and also questioned the victim's age documentation. However, the court said that there was no reason for the victim's mother to falsely accuse the appellant. She arrived at the scene shortly after the incident, saw the appellant next to her bleeding daughter, and had no reason to protect the real culprit. Therefore, the appellant's conviction was justified. Further, the court found that victim's age was credible based on medical testimony and circumstantial evidence. Justice Subodh Abhyankar upheld the conviction and said that despite ongoing concerns raised by constitutional courts since the Nirbhaya case in 2012, the legislature had not made significant changes, which continues to disappoint victims of such crimes. And lastly, an affidavit has been filed before the Kerala High Court stating that despite issuance of notices to RSS members and filing of complaints with the police, the Shakha activities continue to take place at the Raktakanda Swami temple. The secretary of the Travancore Devaswam Board submitted the counter affidavit on behalf of both the Devaswam Commissioner and the subgroup officer. The affidavit was filed in a plea moved by devotees and nearby residents alleging illegal encroachment and unauthorized use of temple and temple premises for conducting mass drills, Shakha activities by the members of the Rashtriya Swayam Sevak Sangh. The affidavit stated that the Travancore Devaswam Board had issued circulars prohibiting conducting of mass drills and other weaponry practices in temples and premises managed by the board. The court was appraised that the subgroup officer has lodged complaints with the police due to continuous Shakha activities of the RSS members in the temple. It is further stated that the Shakha activities are continuing despite strict warnings from the police. The affidavit also states that the activities are conducted in the temple premises with the support of the Temple Advisory Committee. The matter will now be taken up on 11th October. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.